Hi there, this is Jonathan Ginsberg. I'm a bankruptcy attorney here in the Atlanta area. And I want to tell you about a part of the law that some people find a little bit frustrating, but in fact we have to deal with it. And that is that if you are filing bankruptcy, your spouse's income, and that would be employment income or any other source of income, has to be revealed as part of your bankruptcy case, even if your spouse is not filing with you. We had a case the other day, somebody called and they were trying to stop a foreclosure, and my colleague Susan Bloom was talking to this person and who wanted to file bankruptcy to stop a foreclosure. And so Susan said, you know, what does your spouse earn? And the caller got very irate. What does it matter what my spouse earned? I don't want to reveal that. It's nobody's business, and basically just hung up on her. Well, the problem is in the 11th Circuit, we're part of the 11th Circuit, your spouse's income is considered as part of your means test, and that's sort of the ticket into filing bankruptcy. And the reason for that is the courts basically say that even if your spouse is earning separate money, and even if your spouse is not filing, you potentially have the benefit of that spouse's income. So let's say that you have a husband and wife, and the husband's not working, the wife is. The husband wants to file bankruptcy to get rid of a bunch of unsecured debts, but the wife is earning $200,000 a year, and the couple is living in a $300,000 house. The bankruptcy court is going to at least assume that the husband, even though he's not working, has some access to the funds, is living there without paying rent, presumably, and that sort of thing. Now, you can rebut that presumption by showing separate expenses, but it's possible for the Chapter 7 trustee and the United States trustee to dismiss a Chapter 7, move to dismiss a case, if your spouse's income is high enough to take you outside what's permitted under the law, either in the good faith test or the means test. Now, what we do when we find these situations is, if the non-filing spouse has specific expenses that he or she has to pay, a car payment, credit card payments, tax debts, we can take those off the top. But absent that, this non-filing spouse's income has to be considered as far as part of the bankruptcy. So again, many times we can get past it, but you can't refuse to provide that information. Because if you refuse to provide it and you file anyway, the court's going to demand it. If you don't turn it over, they're going to dismiss your case. So that's one of the things you need to be aware of if you're thinking about filing bankruptcy, even if you're unemployed, even if you have very low income, but you have a spouse who is earning money. And that could certainly be a situation that could be one that could create some problems for you unless you prepare for it ahead of time. The time to figure out if there's a problem is before you actually file, not after you file. So I hope this has been helpful. Again, I'm Jonathan Ginsberg. If you like this video, please give it a thumbs up on YouTube, like it on Facebook, share it on social media. And if you have any questions about this or any other personal bankruptcy matter, please feel free to let me know. Thanks a lot.